Good afternoon, everybody. My name is Allison Donovan. I'm a member at SKO. I practice out of our Lexington office. I focus my practice primarily in the area of the banking industry, particularly in the area of banking sales and acquisitions. Also handle regulatory matters and then corporate governance. But today, the topic that I'm going to be talking about really is in the context of general corporate matters, corporate governance matters. So I think it's going to be relevant and applicable across all different industry groups. I know in prior SKO presentations, there's been a request for feedback that it would be helpful to have some topics that relate to more transactional matters. And so being in a position to assist your board of directors fulfill their fiduciary obligations is definitely a topic that we think is important and something that would be of interest. Please know after listening to this presentation, if you'd be interested in having kind of a similar but more streamlined presentation made to your own board, that's something that I'd definitely be happy to discuss offline and help facilitate. Before I go any further, I do want to just mention that this presentation is going to be recorded. After we finish and get it edited, it's going to be posted to our SKO YouTube channel. And then following the presentation, you will receive an email from Renee Lamb, who does a great job with our marketing department to facilitate and coordinate these events. That email is going to have the Indiana and Kentucky activity code that will allow you to submit for CLE credit. We were able to get this presentation approved for 1 hour of regular CLE credit, both in Indiana and Kentucky. So be on the lookout for that email. And also the email is going to contain a link to a SurveyMonkey. We would really appreciate if you could take a couple of minutes and complete that survey. It does help us with the feedback to make sure that we're delivering types of presentations that people find of interest. So I'll go ahead and get started. I've already started sharing my screen, so you should have my presentation materials up. So again, we're going to talk about fiduciary duties of the board of directors and related matters. Okay, so this presentation is going to discuss a company and the structure of a corporation. You know, we do see a lot of LLCs used for certain types of organizations, but there are still a lot of companies that are organized as a corporation, and that makes sense for various reasons. As an overview, in the context of a corporate structure, we have, board of directors. They owe fiduciary duties to the corporation that they serve on, as well as the shareholders of that corporation. So that's what we'll be talking about today. It's going to be, all of these points are going to be at kind of a high level overview. Now, in some situations, directors can be subject to personal liability if they breach their fiduciary duties. So it is important that there's an understanding about what those obligations involve. During this presentation, I'm going to talk about the core fiduciary duties of care and loyalty, and then some specific obligations that flow from these core duties. The standard of review that courts tend to apply when they're determining whether or not directors have met their obligations, and then some thoughts on how directors can or corporations can limit the exposure of liability for their board. So there are some specific circumstances when a corporation that has that structure isn't required to have a board. It tends to tie to the number of shareholders. But in most cases where you're utilizing the corporate structure, you're going to have a board of directors. And if there's a board of directors, then it's going to be their ultimate responsibility to care for the business and affairs of the corporation. The board's power to manage the corporation is typically codified by statute. I've included the two provisions under Kentucky law and Indiana law that control. So, for example, in Kentucky, that statute expressly states all corporate powers shall be exercised by or under the authority of, and the business and affairs of the corporation managed under the direction of its board of directors, subject to any limitations set forth in the Articles of Incorporation. So, shareholders in that role of shareholders, even if it's a majority shareholder, is not going to be responsible for management of the corporation. While they have a fundamental right to elect directors, thereafter it's the board who has oversight of management of the corporation. And so that's why, for example, it's the board that makes decisions about and appointments of officers, because officers are the ones in management that oversee kind of the day-to-day operations of a company. And since that right to manage is reserved for the board, it's appropriate for the board to appoint officers, not shareholders. For example, in one court case, this was a court in Delaware that ruled that shareholders couldn't amend their bylaws to give them the right to appoint the shareholders the right to appoint officers, because that's something that's reserved to the board, and the shareholders don't have the right to manage the corporation. And just a note, from time to time, I will make reference to Delaware law. You may be aware that a lot of corporations are incorporated in Delaware. One of the reasons for that is because Delaware has the quality of judges and decisions that come out of those courts. They have a special court, the Court of Chancery, that's dedicated to ruling on corporate disputes without juries. And so due to the numerous amount of cases that these courts tend to hear, there's a greater likelihood that these courts have probably considered issues that are in the context of corporate matters. And so a lot of other jurisdictions look for guidance to the Delaware courts, especially where they don't maybe have case law that hits directly on point. That doesn't mean that it's automatic, but Delaware law can be persuasive. So it's also possible for, under both Kentucky and Indiana law, they do permit for the corporation's organizational documents, so that would be like the articles and the bylaws, to allow the board to delegate some of its power to a committee of directors. This is something that can be done to take some of the obligations or duties off of the board, but there are certain ones that will be carved out per statute. So things like adopting, amending, or repealing the corporation's bylaws is not something that the full board could delegate to a committee of the board. Also, it's important to remember that directors are protected from liability where they are reasonably relying on information that comes from these committees. It has to be a good faith reliance, but there is an understanding that if they have set up these other groups to look at things, that it's okay for them to look at those reports and then consider those when making decisions. So let's talk about the sources of director duties. There are three general components. So we'll start with the state corporation statutes. So I've listed, both, for example, we have the Kentucky Business Corporation Act, the Indiana Business Corporation Law. Then you would have the Articles of Incorporation. Some states call them a charter, but in both Kentucky and Indiana, it's Articles of Incorporation. And then, and that's the document that, gets filed publicly with the Secretary of State, and is really the document that legally establishes the entity. And then you have the bylaws, which are more of an internal document. Those aren't usually filed publicly. And, if you have a regulated entity, for example, a financial institution, there may be some other applicable law that comes directly from their state or federal regulator. So these three sources, statutes, articles, bylaws, they kind of comprise a hierarchy. So for example, if you have a bylaw provision that conflicts with a provision in the Articles of Incorporation, that bylaw provision is going to be void. Or if you had an provision in the Articles of Incorporation that conflicts with the statutes, then that statute is going to control the provision in the articles is going to be void. And then we can't exclude the impact of case law. As I mentioned, there are particularly in certain jurisdictions just decades old common law that has formed the basis for how we interpret fiduciary duties for boards of directors. So as I mentioned earlier, we've got core fiduciary duties. These duties are made up of the duty of care and the duty of loyalty. There are ancillary duties that kind of stem or flow from these core fiduciary duties, which we'll discuss a little bit later. And then in addition to fiduciary duties under law, there may be other obligations that are put on the board that could come from the organizational documents like the articles or bylaws, that could come from corporate policy that's in place. It could, for regulated entities, you may have regulatory requirements. And then if you are talking about a public company, then you would have to take into consideration any requirements from the SEC or maybe the the stock exchange if there are listing rules that come into play. So before we drill down a little bit more into the core fiduciary duties, just briefly, it's important to keep in mind that the directors owe these fiduciary duties to the corporation and to the shareholders. If there's a breach of the fiduciary duties, it's the board that's going to be the subject of a complaint, not the corporation itself. And to the extent that there are common stock shareholders and preferred stock shareholders, where those interests kind of diverge and go different directions, then there is law that has been established that the board is going to probably owe its fiduciary duties exclusively to the common stock shareholders. If you've got like creditors of a solvent corporation, those are generally going to be protected under creditor and debtor laws and just contract law. And so they're not going to be, it's not the corporate law really that comes into play. So the duty of care is our first core fiduciary duty. The statutes talk about this fiduciary duty as acting on an informed basis. So this core duty is generally described as the obligation to use the amount of care that an ordinarily careful and prudent person would use in similar circumstances. But breach can also occur if there's an omission as well, because a director would be considered as breaching his or her duty of care if no action's taken in a situation where a careful person would have taken action. So, for example, if there's an allegation of fraud being committed, a director could be held liable for the breach of duty of care for failing to stop the fraud if, for example, that director failed to attend meetings or maybe monitor management to where they should have been aware that something was going on, and they take no action, I guess, to agree that the court would consider grossly negligent. As we'll talk about later in the presentation, what's called the business judgment rule is what protects the board from liability under ordinary circumstances for most business decisions. The board can't be held liable for making decisions simply because another decision would have been more profitable for the corporation. There is a Delaware case that gets cited a lot that says that there's no per se obligation on the board to maximize the profit of shareholders. I think what may be a more accurate statement is that there's an overarching obligation on the board to make sure that the directors are acting in the best interest of shareholders, but there can be carve-outs from that obligation that come into play that permit the directors to maybe favor the interests of non-shareholder constituencies at the expense of shareholder interest, so long as the action is reasonable. So, for example, as I've got on this slide, if the directors want to authorize some kind of charitable contribution or donation made on behalf of the corporation that shows, that the company is a good community citizen, things like that, where there's a rational business purpose for taking that action, even though it doesn't increase and maybe decreases shareholder profit, is typically not going to be considered a breach of duty. So it's not going to be, they're not going to have liability for taking those types of actions. Okay, so our second core fiduciary duty is the duty of loyalty. This duty requires that directors put the corporation's interest ahead of their own. And so this involves not just an affirmative duty to protect the interests of the corporation, which is kind of the purpose of the duty of care, but it's also an obligation to really refrain from any kind of conduct that would injure the corporation and its shareholders or deprive them of some kind of advantage. So practically, one way that the duty of loyalty could be breached is if a director usurps some kind of corporate opportunity. And there have usually been several factors that get analyzed to determine whether or not that corporate opportunity rightfully belonged to the corporation. So, you might look at whether or not the corporation was financially in a position to take the opportunity. or if it's an opportunity that's in the same line of business as the corporation. Does the corporation have an interest or expectancy in that opportunity? So, breaches of the duty of loyalty, as you can see, tend to be more serious than just breaches of the duty of care. So now that we've considered the core fiduciary duties of care and loyalty and a little bit more about what those mean, we'll talk about how those play into the board's conduct. So as discussed, the board, is to manage the corporation by making decisions on how the corporation should operate. And if these business decisions are made, directors are typically going to be protected by what's called the business judgment rule. This presumes that directors are disinterested and independent, that they're acting on an informed basis, in good faith, and with the honest belief that the action that's being taken is in the best interest of the corporation. So after a decision is made, if that decision is challenged, courts have historically been reluctant to substitute their own business judgment for the directors or to try to question whatever the decision was made with the benefit of hindsight, unless it's just clear that the decision can't be attributed to any kind of rational business purpose. This is to give directors a measure of space for risk that they have to take in order to make decisions that will benefit the corporation. So as a result of needing to have this space to take risk, then director actions are protected by this presumption of the business judgment rule. And when you look at the formulation of what the business judgment rule involves, that kind of helps hint at the presumptions of how you can rebut that presumption. So, for example, if a majority of the directors aren't disinterested and independent, the business judgment rule doesn't apply. If the directors are acting in bad faith, the rule doesn't apply. So, looking a little closer at these elements that comprise this rule, keeping informed. So, directors have a duty to inform themselves prior to making business decisions of all the material information that would be available to them. Directors should be made aware that they need to participate in board actions. So this means regularly attending meetings. That can be in person, by phone, virtually. We've seen that happen a lot more over the last couple of years, and generally that's fine so long as everybody can hear what's going on in that meeting. But carefully reading reports or other materials, asking questions. Again, directors can rely on reports that are provided, from management or other counsel or other advisors, and they need to be sure they feel that those persons who have prepared those reports are competent, so that they can make an analysis related to that decision. But practically speaking, if you are somebody who's responsible for getting information to the board, it should be done at least a few days in advance of the meeting so that the board has a chance to consider it, even if it's at a high level summary with the ability to provide, more detailed information upon request. That's important to get that information to them. And then we're seeing more clients who utilize some kind of electronic portal that the boards have access to. That can be really useful because it can make it easier to prepare information, get that disseminated quickly, make updates if you need to. Of course, you've got to be maybe more cautious about security issues in that case. But one other note of caution, it's never good to just kind of view it as doing a data dump on the board. That's not going to be helpful for directors. You really want to try to provide them with information that's material to the decisions that they're going to be making. And, sometimes you have people who serve on multiple boards. And if that's the case, it's just important that they don't spread themselves too thin so that they don't have the time to really commit and dedicate to their service as a director. I know in some industries, like banks, for example, there are actually limitations on serving on multiple bank boards where, they're within a competitive market. It's called the Management Interlocks Act. So, if you're in a regulated industry, you may just want to be sure that you're aware of any restrictions or limitations on board composition. So the next element related to the business judgment rule, good faith. Directors have to act in good faith. They don't want to, this decision-making process isn't a matter of just kind of rubber stamping what management says. They really want to make sure that their decision-making process is substantive. And courts have frequently defined good faith as the absence of bad faith, which I know is a little bit abstract, but later in the presentation, we'll talk a little bit about how a plaintiff might establish bad faith. And then again, directors have to act in the best interest of the corporation. So this is a reasonable belief that whatever decision is being made is in the best interest of the corporation. So if the majority of the board qualifies for this presumption of the business judgment rule, then the standard for finding a breach is going to be gross negligence. Just a quick note that sometimes there'll be a claim related to corporate waste, but in this type of situation, a plaintiff would have to prove that whatever was going on was so one-sided that no ordinary person would conclude that the corporation received the right consideration. So it's considered to be more of a stringent standard that really is met in rare cases where there's just some kind of irrational basis for what seems like just giving away the corporate assets. So things like, it's very often for boards to approve things like employee vehicles or some of their kind of outings, social club dues, holiday gifts. All of those things really can tie back to some kind of rational business purpose, and so those wouldn't be the types of decision making that would support some kind of finding of corporate waste. So as mentioned, when the business judgment rule is in play, then the standard for finding a breach is going to be gross negligent. If you're going to try to hold the board to a higher threshold of liability, then their action is going to really have to exhibit a greater degree of culpability. So that would be looking at things like willful misconduct or knowing violations of the law, dishonest acts. It can be permissible to have a provision in the articles that eliminates or limits the personal liability of directors for monetary damages. It's called an exculpation clause. But no, this is really only applicable in the context of a breach of duty of care. It's not available where there's an allegation for a breach committed in bad faith, because that's identified or analyzed as a component of the duty of loyalty. And same thing for breaches related to conflict of interest. Those are both, that's also considered under the duty of loyalty. So those types of clauses, while available for the duty of care, not available for the duty of loyalty. And please note that these types of provisions, they don't exculpate for things that happen prior to the effective date of the provision. But it is something that can be important on including in the articles of incorporation, especially if you're dealing with a corporation that's been around for a long time and maybe has dated articles. That's something that we do pretty regularly, is look at the corporation's articles and check to see if there are things that need to be done to update and make them a little bit more modern and consistent with some of these provisions that have become available in the last few decades. Okay, so let's next turn to the duty of loyalty. Unfortunately, there's no real single definition or set of factors that exist to define good faith or bad faith, but there have been court decisions where courts have identified situations that usually involve bad faith, so those can be instructive. So this would include things like the intentional failure to act. So for example, if a director knows that management is violating corporate policy, but then makes no attempt to address the situation, that would usually be considered as involving bad faith. And knowing violation of law. So for example, if the directors have approved some kind of waste removal plan, knowing that it's going to violate environmental laws, that would be identified as bad faith. Also acting for another purpose. So there have been examples where if a director approves a sales transaction because the director has some kind of really desperate need to sell his or her stock, that might be considered bad faith. So as we discussed earlier, a finding of gross negligence is necessary to establish the breach of the duty of care. An act taken in bad faith, it's got to be more culpable than just gross negligence. So there's got to be this kind of element of actual or constructive knowledge related to the action that's necessary. We'll talk just a little bit about bad faith through the failure of oversight. This is something where you might see a claim that would try to negate the presumption of the business judgment rule, where there's not a conflict of interest, but the plaintiff is trying to establish bad faith on the part of the board. Sometimes this is referred to as a Caremark claim because it comes out of a case in Delaware. In these cases, what is being alleged is that the board did so little to oversee the corporation's operations and exposure to risk that failure amounted to a conscious disregard of its duties, which is recognized as an element for establishing bad faith. And so, by consciously failing to monitor that, the basis of that liability is going to have to require the plaintiff to point out that there were red flags along the way that kind of put the directors on notice that there were problems with the controls or system of the corporation, and that then those red flags or situations were just completely disregarded. Historically, these types of claims have been considered very difficult theories to try to win judgment as a plaintiff. But interestingly, over the last several years, there have been some cases out of the Delaware courts that have kind of suggested that maybe directors could be more exposed to those claims than they've been in the past. So even though this case has been around for many decades, it just is looking to see that, and those still stress the high bar for pleading this type of situation. But it seems like the Delaware courts maybe have a willingness to entertain that if, for example, the oversight claim involves some kind of essential and mission critical issue for the company, that might then mean the board did have this conscious disregard. Again, these cases continue to repeat that the standard is very difficult to plead, but just, in practice, it'll be interesting to see how that plays out. And, if there will be more claims that start going in favor of the plaintiff versus the board. Again, Delaware law is not, it's just persuasive on Kentucky and Indiana courts, but these developments in Delaware law, it just highlights that it's very critical and important for companies to make sure that their boards are adopting and then regularly assessing, evaluating, updating their internal controls and reporting systems so that they can try to avoid potential liability for a failure to oversee. Another way that plaintiffs could try to get around an exculpation provision is to establish that a majority of the directors were conflicted, so that they were not disinterested, they were not independent. And if a director commits a breach of their fiduciary duties where there's this presence of a conflict, then they'll be deemed to have breached their duty of loyalty. Again, this type of breach can't be exculpated away. So decisions or transactions that involve some kind of conflict, they're not protected by the business judgment rule, but they're adjudged for the fairness of the deal, both on process and price. And when we're looking at whether a conflict exists, you really have to look at the disinterested status, the independence of each director on an individual basis. If a majority of the directors are disinterested and independent, then it helps the rest of the board. The board as a whole remains entitled to the presumption of the business judgment rule. But if half or more of the directors are not disinterested and independent, then you're going to need to review that decision of the board for fairness. So to provide a little more detail about these elements of disinterest and independence, included a couple of general points on this slide. So, for example, with disinterest, if a director has a material financial interest in a transaction with a third party that isn't shared equally by the shareholders, that would be considered an issue in considering whether the director is disinterested. If it's a transaction involving self-dealing on the part of the director, again, the director is not disinterested. And in the case of self-dealing, you're really not even looking at whether it's a situation involving materiality. when you are looking at a financial benefit and whether it's material, it's in the context of that director's personal financial circumstances. And so you're looking at whether the benefit to the director makes it so improbable that the director couldn't perform his or her obligations to the company without being influenced by this overriding personal interest. So that benefit causes, the director's personal interest to kind of diverge from the shareholders' interest at large. But the fact that the director owns shares in the corporation does not in and of itself mean that a director is not disinterested. In fact, courts frequently see the fact that directors hold stock within the company as maybe aligning the director's interests with the rest of the shareholders. But for example, a director who's considering their own decisions that involve their own compensation, that would be a situation where that director is going to be considered to be conflicted as being not disinterested. And then with independence, there's a presumption of independence that has to be rebutted. And so to successfully challenge that, usually a plaintiff is going to have to show that the director was so much under the influence of some controlling shareholder that they really didn't have discretion in making decisions. But the ties have to be very sufficiently substantive so that the director couldn't have objectively evaluated the decision. These situations can be very fact specific. They're not always easy to predict. Practically, it's probably a good idea, if you aren't already doing this, to have some kind of questionnaire that you have each director complete regularly, maybe annually, so that the director can alert the corporation to any relationships or other situations that could impact whether the director's not disinterested or independent. I know regulated entities tend to have requirements about having this type of information within their corporate records, making it available to their regulators. But really, it's a good idea for all corporations just to be aware of the director's personal situation. This can help avoid issues as they arise. And certainly if the director completes information and gives it to the company and then something changes, then those types of changes where there could be an issue should be made known to the corporation as soon as possible. So if a conflict transaction has been found unfair, then directors can typically be found liable in one of two ways, and it turns on whether they themselves were conflicted. So directors who were disinterested and independent can be held liable, but usually just if the situation has been approved in bad faith. The disinterested and independent directors may be able to win dismissal of the complaints and get them at the pleading stage and not have to remain defendants through the whole course of the litigation. But directors who lack disinterest or independence are typically going to be subject to damages regardless of the subjective bad faith. So the business judgment rule can be restored for decisions or transactions that involve a conflict of interest if the decision is ratified by a fully informed, disinterested vote of the shareholder. This can be, at a meeting of the shareholders, or as I mentioned, or I guess it's both Kentucky and Indiana law allow written consent by all the shareholders without a meeting. But if that route is pursued or you're doing it by written consent, it's very important to follow all of the requirements of those statutes that allow for written consent in order for that ratification to be effective. As discussed, something like directors making decisions related to their own compensation. Ratification of that compensation by the shareholders might be an available option. And then, if a corporation has a controlling shareholder, then in a transaction where that controller is on both sides of the transaction, the approval of the majority of the minority shareholders isn't going to on its own restore the presumption of the business judgment rule, but it does help shift the burden of proof to the plaintiff to prove that the transaction was unfair. It's also possible for the board to form a committee of disinterested and independent directors to make a decision that would otherwise constitute a conflict for other members of the board. This, again, doesn't restore the presumption of the business judgment rule, but it does shift that burden to the plaintiffs to prove that the transaction was unfair. So let's move on to some heightened standards of review. The business judgment rule can sometimes be restored, as just talked about with shareholders, where they ratify a conflict transaction if certain procedural steps are taken. But preliminarily, in some of the situations that are described on this slide, the business judgment rule is not going to be available because there's this specter of a conflict of interest, because the director's action or inaction could damage the fundamental rights of the shareholders. So this standard of fairness, it's considered one of the most onerous standards. It's normally applied in 3 different situations. You have a conflicted board, conflicted controlling shareholder, or fraud on the board. So if you have a conflicted board transaction, you can avoid that fairness standard if a majority of the directors involved in the decision are not independent and disinterested, but convening a special committee of independent and disinterested directors to take charge of the relevant issues can then help the court's deference under the business judgment rule. It's the source of the conflict of interest is a controlling shareholder on both sides of the transaction. Then convening the special committee doesn't on its own restore the business judgment rule, and the entire fairness standard has been applied. If the controlling shareholder is not on both sides of the transaction, but for some reason receives consideration that's different from the rest of the shareholders. And then fraud on the board, the application of this fairness standard, when it's actually recently become more of a focus of courts. And so what this theory requires is that even just one director be conflicted, that the board be inattentive or ineffective, and that there's maybe been some kind of manipulation by the fiduciary that has self-interest. So in these situations, again, it's the defendants that have to show fairness of the transaction or the decision. And we're looking at both fairness in terms of dealing or process and fairness in price. The distinction between price and process isn't always completely clear. Also, the inquiry, it's not one that's bifurcated. So the court conducting the fairness review is going to kind of examine the whole transaction for both procedural and substantive fairness and reach a unified decision or conclusion. And while usually if you have a fair process, that's going to result in a fair price, that isn't always the case. So I just put a couple of examples of cases where this maybe happened. So like in the first example, the Delaware Chancery Court concluded that a merger satisfied the entire fairness in spite of an unfair process that led to it. The court held that the directors were personally interested in the transaction, that the board had wrongfully considered only the interests of the preferred stock to the exclusion of the interests of the common stockholders. But because the court deemed that the deal fair on price, because the value of the common stock of the company as a going concern actually would have been worthless. In contrast, in this other case, it was a recapitalization transaction. The price was fair to the common stockholders. It still failed the entire fairness review, though, because it was an unfair process. Kind of to rationalize the conflict maybe between these two cases, the court distinguished recapitalizations because the shareholders remain on as shareholders in the company. And they distinguished that from maybe a third-party merger where price becomes the more critical element. So if the board acts with the primary purpose of interfering with the fundamental rights to elect directors, then they have to show compelling justification for doing so. So typically they would have to show that there was some kind of legitimate corporate objective that's motivated by good faith and that wasn't trying to preclude the shareholders from their right to vote or to coerce them to vote in a particular way. and that whatever actions were taken were reasonable in relation to the threat. One example that court considered was that there was justification that was compelling to postpone a shareholder vote to use that time to get more votes for a merger. And then another third situation, sale of the company. So this slide kind of provides a brief overview of the main principles that come into play in the context of a mergers and acquisition transaction. If the board decides to pursue a sale, it should always consult with legal and financial advisors for full discussion about what the board's duties are. This is a very specialized type circumstance where that advice is going to be very critical. It's almost always advisable that the board obtain some kind of fairness opinion from the financial advisors. That's something that both parties, buyer and seller, are going to be interested in. Practitioners sometimes refer to the board's duties in the situation of a sale as the Revlon duties, based on a case that came out of Delaware. But in reality, their duties don't really change. They just become more directed and focused to making sure that they have the goal of obtaining the best price that's reasonably attainable. So in this case, the standard of review changes to one that's enhanced. And so the court is looking at the board's conduct for reasonableness. And these, I guess, the Revlon duties, they don't become subject to that just because the corporation is in play or is a candidate for a takeover. But once the agreement to sell is in place, then that comes into play. And usually highest value is interpreted to mean the highest purchase price, but the board can consider other factors, whether or not there are financing contingencies that are going to make it less likely that the deal is going to be completed, or whether there are going to be, different governmental consent requirements for one particular buyer versus another, again, to make a deal less likely to close. So a vote by the fully informed and uncoerced shareholder, it allows the business judgment rule to be restored even where Revlon would ordinarily apply. And you think about it, if the fact that persons of ordinary sound business judgment, the shareholders, are voting and considering the transaction fair, then that's going to be considered as or looked at and analyzed. So as a practical matter, when you have a Revlon claim, it's usually dismissed once the shareholders have approved the transaction. And the board also has a duty of disclosure. It's kind of one of those ones that flows from these other core duties. It can also be referred to as a duty of candor. It kind of stems from the duty of care. And it's relevant for several of the things that we've talked about in this discussion. The standard of review can't shift from entire fairness or reasonableness to the business judgment if the vote of the shareholders isn't informed. They can't be informed if they don't have adequate disclosure of information. So while the board isn't required to disclose everything, obviously there are some things that need to be kept confidential. The board needs to have the ability to discuss things openly, but there are some examples where there is an obligation to disclose certain information. So, like, for example, if the board is seeking statutory approval or the statutes require approval for an action, then the directors would have to disclose fully and fairly all material information that the board controls. So if you've got a merger situation, that's a transaction that requires statutory approval by the shareholders. And so in the proxy statement, for example, that's going to describe that transaction, it would be misleading if there was a failure to talk about the CEO's personal financial interest in the merger. If they're going to continue on with the continuing entity and have some kind of comp arrangement or things like that, those would be matters that would need to be fully and thoroughly disclosed to the shareholders. Or you might have the duty of disclosure arise where the board is seeking to ratify some kind of transaction, and because the director has some type of personal interest that conflicts with the corporation's interest. So in that case, directors would need to disclose the material facts that the board is aware of. Or where if the director is communicating publicly or directly with shareholders, the director has to be sure they're not speaking falsely so as to misinform the shareholders. So in other words, if they're disclosing any information, it needs to be truthful. So a corporation has a legitimate interest in securing talented persons to serve on the board. That's going to help the board have good, just different perspective and lots of good ideas flowing. So they want to be able to recruit, retain talented people to serve in those roles. So there is a reason to want to have protections in place to help limit or shield against directors from facing exposure to potential personal liability for claims made against them while they're serving in that role of directors. Again, that can be very important in trying to retain or recruit and retain quality people, because that's just going to advance the goal of maximizing shareholder value. So we'll talk about just a couple of approaches that can be used to provide a measure of protection to directors. This relates to indemnification and insurance. So I've actually listed three main ways that a corporation can limit exposure to personal liability. We've talked about a provision in the articles, for example, to eliminate or limit personal liability for the breach of the duty of care, but we'll talk a little bit more about indemnification and advancement, and then directors and officers insurance. These will be explained more on the next couple of slides. What I try to do is put the different statutes in Kentucky and Indiana where these topics are discussed. So first, for indemnification and advancement, under both Kentucky and Indiana law, there's mandatory indemnification. So it requires a corporation, unless it's otherwise limited by its articles, to indemnify a director who's made a party to proceeding by reason of the fact that he is serving, or he or she is serving the corporation, if they're wholly successful on the merits or otherwise in that proceeding. Then at the other end of the spectrum, the statutes also say that the corporation is not permitted to indemnify a director where the director is adjudged as being liable to the corporation, or where they're judged as receiving some kind of improper benefit. These provisions for indemnification and advancement can be included either in the articles or the bylaws. If it's in the articles of incorporation, then approval of that is going to require both the board of directors and the shareholders in order to include it or change it, anything like that. Typically, boards are allowed to amend their bylaws without a shareholder vote. So you see it there too. Sometimes you see it in both places, and that can be, you just want to be sure that it's consistent, that the provisions are consistent. So I know that's something else that sometimes we work with clients to review and see what does each say, and make sure that if it is in both places that it's consistent, or maybe opt to just include it in one document over the other. Advancement of expenses, it's permitted, but it's not required under the statutes, although directors usually are going to be more inclined to want to serve if that is something that the corporation obligates itself to do by including that in the bylaws or the articles. They usually expect that they're going to receive advancement of their expenses, but not surprisingly, this is an area that can be ripe for litigation, although the courts are generally skeptical of a claim by the corporation that the director is not entitled to advancement where they're working or serving in that role of a director, not in their personal capacity. And then insurance, both Kentucky and Indiana statutory law contain provisions that allow or permit a corporation to purchase and maintain what's called direct D&O insurance, usually directors and officers insurance. This is on behalf of current or former directors for liability that relates to their actions taken in that capacity. This slide lists the three most common types of D&O coverage and the purpose of each of those. Somebody who's a smart director is probably going to want to be sure that the corporation has purchased adequate D&O insurance to protect them against a breach of fiduciary duty claims. The directors should review this periodically to make sure that they've got the fullest coverage available and understand, what the risks are retained by the corporation, what are the exclusions of the policy. It can also be a good idea to check into the insuring company and just see what their financial strength is in the event that there was a claim made. Also keep in mind that a D&O insurance policy that responds to a claim, it's the policy that's in place at the time that claim is made. So if you're looking, if you got an action that's taken in 2021, but it's later challenged in 2022, it's that 2022 policy that's going to respond to that claim. And this is where what's called D&O tail coverage may be critical or crucial. That you see a lot in the context of a sale of the company. A tail policy covers what would otherwise be a gap in coverage for directors after the sale of a company. If you have a tail policy purchased, though, as part of the sale transaction, then that insurance carrier for the selling company is going to agree to hold open the D&O policy for a specified period after the sale date. Usually the standard we see is 6 years. Usually priced it as a percentage of the existing annual premium. It is typically in the 200 to 300% range. The good thing about tail policies is that usually they can't be canceled. So that guarantees former directors of the seller that they don't run the risk that the buyer is going to try to cancel the policy after the parties close in order to get cash paid for the policy, get back the cash that's paid for the policy. So as we kind of wrap up, just a couple of points, I guess, to summarize this presentation. Again, this was kind of all at a high level, but for all the complexity that fiduciary duty, standards of review, that are out there in case law, the bottom line really is that, what's going to help the board fulfill their fiduciary duties is to be focused on ensuring that they're engaged in deliberations, that they're acting reasonable, that they're regularly attending, participating in meetings, that good corporate records of those things are being kept. You want to consult, the board should consult with counsel and experts if it's necessary. If there are conflicts of interest, that can happen. And instead of just trying to sweep them under the rug, it's better to get them out in the open, discuss them, keep a record of that the board has talked about it, considered it, and then take an appropriate steps to deal with it. Directors on an individual basis, and then the board as a whole, if they are taking these steps, that's going to go, and then also making sure that there's a record that they did this, it's going to go a long way in helping them avoid liability. You really want that corporate record to tell the board side when it comes to some of these issues. You don't want after the fact testimony. If there's a situation where the board's conduct is being reviewed by court, obviously that good corporate record of these things is going to have a lot more credibility than kind of after the fact conversations.